Order, order. Good morning and welcome to the meeting of the Public Administration and Constitutional Affairs Committee. Today the committee is continuing its inquiry into the Coronavirus Act 2020 as it reaches nearly 2 years on our statute books and its inbuilt expiry date approaches. As we transition out of the COVID-19 pandemic, it is right that Parliament should review the emergency powers that have been introduced into our legislative landscape and examine their ongoing impact and effects, as well as what options there are for future emergency legislation. I'm delighted to say we're joined this morning by the Secretary of State for Health to discuss this legislation following the Prime Minister's recent announcement on the government's plans for living with COVID. Secretary of State, I wonder if I could ask you to introduce yourself for the record.
Thank you very much. And I'm Secretary of State for Health and Social Care. And if I may just say at the start, can I thank you, Mr. Chairman, and the committee for this opportunity to appear in front of your committee today. And as you say, 2 years ago, the legislation that was introduced was unprecedented. It was an unprecedented piece of legislation in every way to deal with an extraordinary threat our country faced. I think we all can understand the purpose of that, but it was a huge restriction that, alongside the Public Health Act provisions that were used on people's on their own freedoms, and also a big shift in, I think we can say, in the relationship between the state and the individual. And I would join you in saying I think everyone can look at the moment we're in now and with the pandemic in a much, much better place as we learn to live with COVID. And can I finally just say at the start, I really very much welcome the scrutiny that your committee has already provided and continues to provide, because I think as we learn the lessons from COVID, this kind of scrutiny is going to be very important.
Very grateful indeed to hear that and have that endorsement, and just say you are very, very welcome this morning. If I can begin with the first question, Secretary of State, will any of the individual provisions that are due to expire be extended, and if so, how and what role do you envisage for Parliament in that process?
Thank you. So, as you referred to at the start, it was a temporary piece of legislation. It's intended to expire as planned at midnight on the 24th of March. In terms of the specific question, the provisions, successively at each review point, a number of provisions have been retired early. What we do intend to do, and we've announced this very recently, is of those provisions, we intend to plan to keep 4 of those provisions on a more, eventually, hopefully, subject to the will of Parliament, on a more permanent basis. And the objective there is that these 4 provisions are things I think we can say that we have learned lessons from already. We think in terms of the impact of them, they can lead to more longer-term reforms, for example, in terms of improvements in the court system and access to courts. And what we intend to do is to just those 4 provisions to keep them going for another 6 months, so there's no gap between those provisions and subject to the will of Parliament, permanent legislation that can come in through existing primary vehicles. That's there's 2 bills in front of Parliament at the moment, and again, subject to the will of Parliament, we hope Parliament would intend to keep the effects of those 4 provisions in place on a more permanent basis through primary legislation with proper scrutiny and debate, but to have no gap, we would intend to keep those for a further 6 months.
Okay, and in terms of those 4 provisions, you've mentioned the courts. Do you care to expand on the other 3 and their necessity?
Yeah, there's 4 in total. There's section, if I quickly go through them, I can expand on any that you wish, is that there's section 30, that's the suspension of a requirement to hold inquest with juries. That's in England and Wales. This has supported coronal services throughout the pandemic in England and Wales, and we would like to try and keep that and make it permanent through the judicial review and the courts bill. And so that's the plan with that, and to extend it for 6 months so that there's no gap. The other 3 are sections 53 to 55, and collectively they are what I might call the remote court provisions. And so those are the provisions that have allowed so far during the pandemic for court hearings to take place using audio and video links. There's around 11,000 hearings per week taking place remotely using remote technology through some 3,200 courtrooms. and they have helped greatly to reduce the backlog in cases and really help bring more justice to more people more quickly. And these provisions we would intend to make permanent through the current bill in front of Parliament, which is the Police, Crime, Sentencing and Courts Bill.
Thank you very much. So just to clarify, is the government intending to bring forward the 25th of March expiry date for any provisions in the Act?
All other provisions. So of the remaining provisions,
they're still going to 25th of March or sooner. To just clarify.
No, on midnight 24th of March.
Thank you.
Yes,
that's helpful. And could I just ask what detailed discussions there have been with the devolved administrations about the impact of the expiry of the Act in March? Is that conversations you've been privy to or involved in?
Yeah, we have continued throughout this pandemic, and certainly the time I've been the Health Secretary, have very regular discussions with the devolved administrations. For myself, I think not surprisingly with my counterparts in the administrations. And the non-devolved provisions we have discussed on many occasions and informed. But ultimately, once these decisions have been made, we've discussed those as well with the devolved administrations. And as you know, there are many devolved provisions which were done through this Act, but there may be, and this is obviously a decision for the devolved administrations, if they wish to keep on within their own domestic legislation, keep some of the devolved provisions, that will be a matter for them.
Okay, that's very helpful. I'm going to move to my colleague, Lloyd Russell-Moore, for me.
Thank you very much. The government justified the passing of the Coronavirus Act with minimal parliamentary scrutiny by saying that it was to protect life. So why have only 27 of the pandemic-related statutory instruments of more than 500 used the Coronavirus Act?
Well, the Coronavirus Act was essentially there to provide support for individuals, for our citizens, as a result of using the regulations under the Public Health Act. So just to be clear, and I want to be clear about this, but I think it's very relevant to our discussions today, is that under the Public Health Act of 1984, that was essentially the vehicle used to introduce regulations around social isolation and self-isolation and lockdowns and all of that. And by exercising that, there was a real significant impact on the citizens of this country, whether it's in terms of their jobs, therefore their livelihoods, their businesses, and in so many other ways. And many other things, such as I referred to the courts earlier, could not continue in the normal way because of these social isolation regulations. So the way the government, the way I would certainly explain the purpose of this Act that we're discussing today, it was there to complement the use of the Public Health Act and to provide support, whether that's to workforce, in terms of workforce, and especially in health and social care, to ease burdens, to support people, helping with some of the provisions to contain the pandemic, but also, for example, to give respect and dignity to the deceased.
When your predecessor said in the House on the second reading that the reason for this Act was to protect life and it would be relinquished as soon as the threat of life was gone. That's not quite true. This Act was to support communities and people being able to continue, not to protect life. That was done via the public health legislation.
It was done by both Acts, because this Act, as I say, I would rather see it as complementing the impact of using the Public Health Act. So if I can share with you, Mr. Russell-Moore, a particular example. In this Act, under Section 2 and I think Section 6, it allowed for the creation of temporary registers. So under Section 2, it's for a temporary register for clinical staff. And that meant that clinical staff that may otherwise be outside of the NHS at that time were able to quickly re-register. I think around 25,000 did. And there's no question, no doubt, that the fact that that was able to happen in the way that it did, it protected life. Other measures that took place, for example, There was a measure to Section 45 to change the NHS pension scheme so that people were not disincentivised to come back to the NHS. That would have saved lives. It reduced burdens such as not requiring the contingents, the continuous health assessments, which meant by reducing those burdens, the NHS could focus more on people that had COVID-19 in hospital. So I don't think it would be correct at all to suggest that this act did not save lives.
I appreciate that. I mean, on the pensions that you've just mentioned there, you've outlined the 4 provisions that you're going to keep. But, I mean, has the government seen any benefit for some of those administrative provisions around the Coronavirus Act, such as the pension waiver in the NHS, that would allow people to come back? And has there been any analysis or consideration about keeping, say, that pensions element that would allow people who have retired to come back? The crisis in the NHS is not over, is it?
I mean, there is a significant workforce challenge in the NHS, of course, and something I've spoken about in Parliament on many occasions. There are aspects of this that we would keep in a way. So the temporary registers, for example, has been, I think, the over and above the pension changes or anything else, the most significant in helping to increase the workforce. And we are working with the respective bodies to look at how that can be put on a more permanent basis, not to keep the register open for new entrants, but for those that have re-registered, for them to be able to continue to practice after midnight on March 24th.
So there is some discussion. I mean, some groups have told us that some of the provisions in the Act were not used.
Will not be, sorry?
Some organisations have told us that provisions in the Act were not used, and this was detrimental to them. The fact that they were not enacted, specifically the triggering of the emergency volunteering leave provision. Organisations such as St John's have told us that hampered their ability to allow people to volunteer. Why did the government legislate for something such as emergency volunteering leave provision and not use it?
Well, I mean, first I would say more generally, before I turn to that provision, that there were a number of provisions that were legislated for and not used. And whilst I wasn't involved in the drafting of the bill at the time, I do think it's understandable that at the time that this was put together at speed in an emergency situation with a virus that we didn't have as much information that we have today, that there was an attempt to try and make sure that provisions that might be needed, but not 100%, people couldn't be 100% sure, were added, just in case. I think maybe later when we get onto the scrutiny, a bit more of this, it was important, I think, that when we had these regular reviews, particularly the 6-month reviews, that each time the government would look at each provision and decide whether it's needed or not. And if anything could be retired early, it was done so. So in December 2020, one of the provisions, for example, on Section 10 provision regarding mental health was retired early and never used, to my understanding. The next review and the one after that, I think some 19 provisions were retired within another 12 months. As for the provision that you mentioned, the government obviously working very closely with the NHS and other health providers, we would have discussed with them in detail, and if from our perspective they had been required to be used, then we would have. You've mentioned St John's Ambulance, and it gives me an opportunity, and thank you for that, to thank them and many other organisations that helped throughout and continue to help throughout the pandemic in respect to St John's Ambulance. Their help, which was provided without any hindrance from legal requirements or legal issues, especially in vaccination centres where they played an absolutely critical role in getting this country and people vaccinated.
Has there been a whole-scale assessment, or will there be a whole-scale assessment, of what was and wasn't used and what impacts each of those clauses has had?
Yes, and absolutely. I think there must be, and there will be. Obviously, the stage we are at now, I'm pleased we're able to make the announcements around retiring remaining provisions. I think that there needs to, and there will be lessons to be learned from this. Clearly, so we can better prepare for the future. And the discussion we're having today, all the other scrutiny being provided, is going to be part of that. But also, of course, the government's own work.
Is that something your department will take on in terms of a public consultation or a public ability for these organisations to input and for you to then collate that and publish it? That's a piece of work, surely, that you would need to lead on.
I think it's very important to do such work. I couldn't tell you today exactly what form it would take. So you've talked about public consultation. That is one potential form. Already, there's a lot of feedback, and very important that the government gets and from various organisations and individuals that the department would deal with. But I think if you're suggesting that a more sort of formal process to that, I think it's a very good suggestion. It's very important.
Good suggestion. So would you be willing to put some meat on that in terms of ideas, timetables? Would you be willing to come back to us?
We are already looking at how we can have a more sort of, let's say, structured, formal process to make sure everyone, not just obviously Parliament's role is absolutely crucial here, but the wider public and other organisations have an opportunity to comment and help improve future legislation.
So when you have the timetable and the form of which that's going to take, you'll be able to write to us.
I'll be happy to write to the committee and say more on that.
Thank you.
Thank you very much indeed. Ronnie Cowan, please.
Thank you very much, Chair. We already had the Civil Contingencies Act and we had the Public Health Act prior to March 2020, and the coronavirus bill was drafted at pace, understandably, in March 2020, but it was repurposed from the shelved draft Pandemic Response Bill from 2016, and it was passed through both houses at an exceptional pace. So, with that in mind, what assessment was done before the Coronavirus Act was introduced of the scope for using the Public Health Act as part of the government's pandemic response?
Thank you for that. I'm very happy to answer that, but we'll just caveat, I wasn't in government at the time, so I can't sort of be perhaps as specific as you might want me to. I was taking a break from government at that time. The Public Health Act, first you referred to that, the Public Health Act of 1984, that as you know, that Act was used. Regulations brought to Parliament under that Act, but the powers that were there under that Act to effectively to help prevent the spread of a communicable disease, the self-isolation rules, the social distancing rules, the tiers, for example, that were introduced, they were all important. They played an important role. But in terms of the subject we're discussing today, I think your question is why. If you ask me why wasn't just that Act used, or perhaps the Civil Contingencies Act, rather than having this new Act? And the answer is that, again, what I was referring to at the start, the Coronavirus Act was there to really deal with the consequences of taking the measures under the Public Health Act that the Public Health Act would not have allowed you to deal with. And if I can share a couple of, I think, of very important examples. I already referred to workforce earlier, to Mr. Russell Moy's question about expanding the workforce in the NHS. The Public Health Act would not have allowed that. There was significant support rightly given to the British people because of the consequences of these so-called sort of lockdown measures. So people's own livelihoods if they couldn't go into work, and that's why the work retention scheme was there, where billions were paid out to people to support them. I think 11 million people or more were supported. There were the business schemes, the bounce back loans, the interruption loans. None of that kind of support would have been possible through the provisions, using the Public Health Act. And also referred another example to the court system. It would have gone to a standstill if people couldn't appear physically in court in the normal way, and therefore these extra provisions were needed. So the Public Health Act would not have allowed those, and these were, let's think of them as support provisions. You also asked me perfectly understandably about the Civil Contingencies Act, and that Act, as I think when that Act originally went through Parliament itself, is that it should be used as a last resort if there are no other legislative vehicles available. And in this case, there was clearly a legislative vehicle available, but also my understanding again under the Civil Contingencies Act is that if emergency regulations are made, I think under Part 2 of that Act, which would have been the most relevant if it were used, that if ministers introduce an emergency regulation, it can only stand for 7 days, and then Parliament has to vote on it, and then that provision has to be renewed every 30 days. So every 30 days on a rolling basis, we'd have to come back to Parliament and renew it, which in itself could have been difficult if Parliament wasn't sitting because of some of the other social isolation regulations. But even if Parliament...
With all due respect, some people would say that's what Parliament's for.
Yes.
And we were available at one point. We could access Parliament through Zoom or technology platforms that are available.
You could.
And we could vote remotely as well. And to ask parliamentarians to every 30 days to re-scrutinise legislation, which is having a day-to-day effect on everybody's life, is really kind of what we're here for, is it not, during something like a pandemic?
I think you're half right, because eventually, as we know, after March 2020, Parliament was able to stand up procedures to allow, for example, remote voting, as you referred to, and remote debate. But even with that, I think the challenge you would have by having to vote every 30 days, you would not be able to provide the kind of certainty that was required with some of those support measures. So, for example, take some of the things I've already mentioned that provided support the workforce. If you had to renew, you want people to join the register, to be registered as doctors, as nurses, as clinicians. And if you had uncertainty that every 30 days they may be renewed, may not be renewed, that would have made the NHS job much harder in terms of planning and how to respond to the virus. The support measures, the furlough measures. Imagine you're off work, you're an air steward, and you know it's not realistic you're going to be back at work for the foreseeable future. Certainly, you're not going to be back there in a month. And then that individual would be sitting at home thinking, am I going to get paid every month, the next month? There's no reliability. If you're a business and you've been given a loan and it's a bounce back loan and you don't have to repay it, let's say for a year, but the legal basis of that loan could disappear within 30 days because Parliament hasn't renewed it, then do you have to pay it back 9 months, 10 months early? So I could go on. There are many measures that required legal certainty, and there are some measures, as you know, in this Act, that there are permanent provisions, that they stay in place, as it sounds, on a permanent basis, because they continue to provide vital legal certainty. If I may, Mr. Cohen, just one example on that, because it is an important point. There was an indemnity, a clinical negligence indemnity, because hospitals couldn't operate in the normal way. There were some settings where they would carry out medical procedures that weren't normal, for example, with local authorities, the vaccination centres that were popping up, and so there was a requirement for changes in clinical in negligence indemnity. Now, if that has to be kept on a permanent basis, so for acts that took place using that indemnity over this 2-year period, they still need to be protected. And if Parliament had to keep coming back every 30 days, then would that clinician have the confidence that negligence would be something, that protection would be there?
It was the half right.
Oh, the only bit you were right about was that Parliament was able... when I said half, I think I was being a bit generous to you. So it was the bit about the remote procedures in Parliament.
If I may...
I was just trying to be nice to you.
For legal certainty, it would be quite convenient not to have Parliament at all to make no changes to the law, though.
But it was Parliament, of course, that when the Act that we're discussing today, when it went through Parliament, of course, the need for that legal certainty would have been explained to parliamentarians, and why it was important to do it this way rather than using the Civil Contingencies Act.
There's always going to be that balance about giving people long-term certainty, and I understand the need for that, and that has to be balanced against an ongoing scrutiny, because you can't just say that's it and it shall not change. So parliamentarians are always going to be re-scrutinising everything that's going on.
That's right, and that's why...
And the public know that, the public accept that, they understand that things can change, and can change quickly.
I accept the principle, and that's why I think it was important when this Act went through Parliament that the government gave the commitments that it did on reports on the status of the use of provisions every 2 months, the 6 monthly reviews, the annual review, and also a very important commitment to retire any powers that either were never going to be used after a better understanding of the pandemic was developed, or provisions you're not likely to want to use again, and Parliament being involved, throughout that process.
The flexibility you're looking for, I mean, the lockdown powers were not set out in the Coronavirus Act. We used the Public Health Act.
Yeah.
So why were they not in the Coronavirus? If you're looking for this flexibility, why were they not in the Coronavirus Act?
Because you didn't need them to be in the Coronavirus Act. That wasn't the purpose of the Act. The purpose of the Act was to support the use of the lockdown measures, to provide support to our citizens.
Okay. So now that the government's used the Public Health Act extensively in the context of this pandemic,
Yep.
what assessment have you made about the gaps in that legislation to best address a future emergency? And are you considering bringing in new legislation to address these? So as come that time, whatever it may be, we're not in a situation we have to legislate at pace.
Yeah. Are you asking about gaps in the Public Health
Yep.
Act or more broadly?
Public Health Act.
First of all, I'd say the assessment, the lessons learned of this, as we also were discussing a moment ago with Mr. Russell Moyle. I mean, that process is going on, and what we're discussing today and what the job of this committee, that your excellent work that you're doing is part of that. If you're asking me sort of right here and now, were there gaps in the Public Health Act, that is an analysis we haven't completed. I think that one of the things certainly to reflect on for the government and for Parliament were knowing that when measures, significant measures are put in place, these restrictions on people's lives under the Public Health Act, and then the impact those have, huge impact on the individuals not being able to go to work, for example, or not being able to run their business and have a livelihood, that I think it's fairly obvious that there's going to have to be support. A government will want to support people in those situations. So I think one thing certainly to reflect on, if it's so obvious that's going to have to happen, that maybe that ability to do that, if it's not in a future revision of the Public Health Act, it's set out more clearly that how governments will be able to do that. I think it's obvious that governments are going to have to support people if measures as they were used, these types of lockdown measures. And so I think that's one thing to reflect on. But in terms of gaps on the Coronavirus Act, I don't think, certainly from my own analysis of it, and again I wasn't involved from the start, there are any obvious gaps in the Coronavirus Act. I think if anything, there were clearly measures that were never used in the end. And I can understand why that happened, but the lessons learned exercise has to incorporate all of this.
What about the draft pandemic response from Bill from 2016? Should we?
Are you referring to the draft flu pandemic?
Yeah. So should
Yeah.
we be dusting that
So,
off?
Well, it was dusted off, and so
Get back into permanent legislation within the Public Health Act.
No, I don't think so. And the reason for that is that understandably and quite sensibly, the government had a draft, let's call it a draft version of what eventually became the Coronavirus Act. But that draft was based on an assumption on influenza being the pandemic. And obviously we now know certainly we had a respiratory disease, a communicable disease, but in terms of its behaviour and particularly asymptomatic transmission is very different from what an influenza pandemic would have looked like. And that meant clearly some of the actions that were taken in terms of isolation, how long you isolated, contacts, and that would have been very different if it was influenza. So I think whilst there's no doubt that the government, Parliament, we have learned lessons. We continue to learn lessons about how to respond to a pandemic. I think we would be, if we tried to sort of bring something to Parliament now on a more permanent footing, you'd just run the risk of preparing for the last war.
What engagement do you see with Parliament going forward?
Significant. I think that first of all, the scrutiny that's being provided by the expertise on this committee, the Health and Social Care Select Committee, the GCHR, the Constitution Committee. I think that's very important, and obviously in the chamber itself. And there's a public inquiry, as you know, as well, that will be that we take into place in much broader than just the legislation, but every aspect of the pandemic. I think that's going to be important as well. I think there will be a lot of lessons to learn over this entire period.
Thank you. I think I'll conclude the session later on with some questions on that very theme, but I think it's the age-old battle, as it were, between the executive and the legislature that we're having symptoms of this morning. But if I can now go to David Mundell, please. David.
Thank you, Chairman. Secretary of State, in the government's view, was the 2-year sunset clause in the Coronavirus Act the right length?
Yes. I don't. Yes.
Uh-huh. Why do you say that? Because would a shorter length not have given Parliament more say?
I think that a couple of reasons. I think if you think back to March 2020, at that point we knew that there was some horrid virus that had entered our country, the world. We knew what we had either worked out ourselves or from the World Health Organization and others. But there was a lot we didn't know. There was a huge amount of uncertainty. Second, we didn't have anything like the defences that we have today, everything from vaccines to treatments and many other things, the surveillance and all of that, testing capabilities that we have. And so we didn't have the tools in the box. And we didn't know if we were going to get them or when we were going to get them. And if we recall, there was huge uncertainty, for example, over vaccines. We didn't understand the virus really enough at all. And at that time, I know vaccines were developed very quickly in the end, relatively to how long vaccines normally take. But, and you might recall, Mr. Munday, at the time, many people, understandably, many scientists were saying, if you're going to get a vaccine for this virus, it will take years and years. In the end, thankfully, it didn't take anything like that, and I'm proud that we were the first country in the world to approve an effective and safe vaccine, and then we've seen how that has made all the difference. So there was a lot of uncertainty, and therefore I think that if you'd gone for 6 months or 1 year, it would have felt too short for these reasons. But if you'd gone for 3 or 4 or 5 years, I think it would have felt too long because for all the obvious reasons. So I think that it was the right balance to have a 2-year date on this. But the second important reason, I think that it was important that there were these regular reviews that were built in. So the 2-month status reports, the 6-month reviews, and they were proper, genuine reviews. Now, I wasn't involved in the first 2 reviews. I was certainly involved in the review that concluded in December last year, when we retired many provisions. Retired, I think it was another further 4 provisions. And those reviews sort of work from the perspective of having that scrutiny with Parliament and listening to Parliament and retiring things early. And I think that meant, whilst the Act itself overall had a 2-year time frame, many provisions within the Act were rightly falling early. So as of today, we've already retired, I think, half of all the non-devolved provisions.
Well, I'll come on to the reviews and reports shortly, but witnesses that we've heard from previously have come forward with the view that sunset clauses generally are regarded as a positive thing, but actually are often a double-edged sword, because parliamentarians are more inclined to accept very draconian provisions on the basis that they would then come to an end, rather than having a shorter period, or actually having an analysis at the time of the provisions. How do you respond to that?
I think in this, what we're talking about today, I think sunset clauses have been positive and played an important role. I think there's always a risk with legislation that clearly everyone would understand is temporary, emergency response, temporary response, and I don't think anyone, even at the height of the pandemic, would have assumed the pandemic's forever, and so at some point, whatever measures you're introducing to deal with it would have to end. I think it's far better the government's sunset legislation. And in the worst case, let's say we never had the vaccines or never made the progress, has to come back to Parliament and justify why it might need to continue. Thankfully, that hasn't happened. This can sunset in 2 years, as it was planned. But I think it's better to do that than to and have that debate again and again in Parliament, whether you need to continue something rather than just allow something to stay on the statute books, where not with respect to this pandemic and things, but in my role in government more broadly, I have seen sometimes quite a sort of an attitude sometimes in government where even when you don't need something that was legislated for a while back, everyone tends to either forget about it, not think about it too much, and it stays on the statute books. And I don't think any law should really be on the books unless it's necessary.
And of course, the government might not have got these provisions through Parliament without a sunset clause.
That's possible as well, yes. I think it's a good point.
In relation then to the reviews which you mentioned, the Act was passed with relatively little scrutiny for the reasons we've discussed, and a minimal ability to make amendments. The subsequent 6 monthly motions have proved to be unamendable and had to be voted on as a whole. So on reflection, do you think Parliament should have been able to be more involved, better informed and consulted in relation to the ongoing operation of the Act?
I think that back in March 2020, given the nature of the emergency and the need to act very quickly for the government, the country to act quickly, I think if I look at how that was handled and the amount of scrutiny that did take place, I think it was justifiable, and it was a balanced way for the government to react in terms of providing opportunity for scrutiny, but at the same time then working at pace to try and get the legislation through as quickly as possible. I also think, looking back, that the review points, the 6-month review points, they've done an important role, played an important role, and it has allowed the government rightly to respond to concerns from parliamentarians. And there are many provisions were either expired or indeed the aspects of them changed because of the parliamentary scrutiny. And in the first review, which took place just 6 months after, Section 10 was expired, and that was the provision, I believe, to have quite draconian powers to detain people with mental health challenges, and it was never used. But it was expired very early on. In the second review in April 2021, 12 provisions were expired. In December 2021, 7 were expired, and part of an eighth. So 20 or 40 provisions have been expired, and that is because the parliamentary process and government not needing it, but also government listening to parliamentarians.
It was based on the government listening to parliamentarians.
Yeah.
It wasn't based on Parliament itself determining those expirations, was it? I mean, the government made the decisions rather than Parliament.
The government, set out its plans, and ultimately, yes, in that respect, the government made the decisions, but the government made the decisions because it had said to Parliament, rightly so, made a commitment to Parliament that if you parliamentarians can support this piece of legislation becoming law, then we will commit to you that because of your support, that these regular reviews will take place, and we will get rid of any provision that was not needed. And so it was a commitment to Parliament, and I think it helped rightly for parliamentarians to support it.
Parliament itself could not have decided to expire a particular provision.
Once Parliament had voted the provisions through. During the 2-year lifetime, Parliament could not decide on individual provisions.
So that was entirely a government decision, but you based those decisions on listening
a government decision, but backed by Parliament in the first place by giving government those powers.
So you don't think that it would have been preferable at some point to have had a wider debate and in Parliament on some of those provisions?
I see what you're getting at, and I think that that should be part of the lessons learned. I think it's legitimate now to think of it in that way, and that when you have legislation like this, I guess your point is that whilst the overall act is needed, could individual provisions Parliament have more say on them, or even a need to sort of come back on, even if it's not all the provisions, some of the more, let's say, controversial ones, the right. And I think it's a very fair point to think about that now.
In relation to the 2-month reports, again, some concerns have been raised about the content of the reviews and the government not addressing some specific concerns that had been raised in those reviews. Again, looking back, what more detail do you think could have or should have been included to enable enhanced understanding and scrutiny?
I think that obviously I've only been involved in some of the 2-month reports, and I've strived in each one to provide as much information, data and stuff as I reasonably can, and I do think it is important to maximise that information and to share everything you possibly can with parliamentarians, and those 2-month report points were clearly an opportunity. I think that's what they should be for. If you're asking that, is it possible to provide more information and things, that I think we should look back at that. At each, it's still worth looking back at each of those 2-month points and revisiting and thinking, as part of the lessons learned about, could more information have been provided? If there was some information government had and it wasn't provided, it's worth thinking about why that wasn't done, and was that in retrospect the right decision. But I do think over having that kind of mechanism, that reporting mechanism, so you had the 2-month reporting mechanism, then a sort of deeper process, which every 6 months, which was like a proper review, was an important part of the scrutiny.
Thank you. Thank you. John MacDonald.
I don't want to labour the point, but the issue was specifically around unamendable motions. And I can understand in certain circumstances why the government would want to put up take it or leave it motions to provide some form of stability of decision making, if you like. And we've all been scarred by the shenanigans around Brexit debates, etc. But having unamendable motions, I think, restricted the opportunity of Parliament of shaping some of the potential improvements in the way the system was operated. I'd welcome that you take that back and consider, as we go forward, whether or not it's better to engage with Parliament more effectively by enabling them to have more say over, and often it would be matters of detail as well, not necessarily driving at the heart of the particular legislation.
Yeah, no, I do, Mr. MacDonald, I do understand that, and as I was saying to Mr. Mendel, I think it's a fair point, and everyone wants to learn lessons from this process, rightly so. It was such a fast pace, it was an emergency, we all wanted to do everything we can to protect the British people, but also we need to remember one of the key ways to protect the British people is make sure their Parliament, their elected representatives feel able to perform a full role of scrutiny. And what you've just talked about, and Mr. Mundell talked about, the idea of having the motions that can be amended, and I think we need to reflect on that.
Thank you very much. Ronnie Cowan again, please.
Thank you very much. In oral evidence given to this committee, Dr. Ronan Cormican said, if something is important, Parliament should debate it, pass it, agree it, and enact it as a proper law. There is this tendency to push things more towards guidance, which does not have the proper parliamentary scrutiny and approval that it really deserves. Do you agree with him?
I think it depends on the context, really. I mean, it depends on the context. So, for example, today we are removing the legal need to self-isolate if you're COVID positive, and we're replacing it with guidance. I think that's the right thing to do. So, would you, if I agreed with that, would you say you should always make it a legal requirement?
On that example, we've already had the regulations for 10 days isolation. But that's been changed through guidance to 7 days to 5 days, and you've not changed the regulation. The law still says 10 days.
That's right, but the law also says that what applies there, if it's not 10 days, is a reasonable excuse. And the guidance sets out what the government would consider a reasonable excuse. So, and I don't think that's unusual in that you have a law, and then sometimes you will have to have, it's very sensible to have guidance around explaining, especially in certain situations, whether the government feels that in that situation it complies with the law or not. But my answer to your question is it depends on the context. And so
do you think doing so much through guidance rather than through legal requirement makes it difficult for people to understand and difficult for people to enforce? You put an awful lot of pressure on the likes of police forces to interpret a law.
It depends. Again, it depends what you're talking about and then the context. So are you referring to measures that were taken under the Public Health Act, which were legal requirements? Or are you referring to measures that were taken under the Coronavirus Act, which is what we're discussing today?
We're using guidance rather than sticking to the legal requirement. When guidance has changed, often guidance has been changed through the use of media rather than through this place as well. People were told over the Christmas period, your guidance has changed. The actual law wasn't changed at all. So how does that put the police force?
But you're not referring to things there that were under the Coronavirus Act. So I'm only trying to clarify, because I thought today we're discussing the Coronavirus Act. But if you want to discuss the Public Health Act and the provisions under there where they should have been guidance regulation, I'm happy to do that. But because I just want to make sure that you understand that under the Coronavirus Act, as I referred earlier, that was a supporting complementary set of measures to other measures that were taken under the Public Health Act. So, for example, I don't see how guidance would have allowed someone to start practicing again clinically in the NHS. That has to be a legal measure. I don't see how guidance would have provided indemnity for clinical negligence. I don't see how guidance would have given someone a bounce-back loan. And so, under the Coronavirus Act, I don't see how guidance versus legislation is really even a legitimate debating point.
The crux of this is, do you think that making changes to things like isolation periods without changing the law was the right thing to do?
Yes, in certain circumstances, and let me explain. So, take that specific example where if the law was at the time that you self-isolate for 10 days, subject to a reasonable excuse, and then the government then wants to very quickly move and say that having a test on a negative lateral flow test on day 5 and day 6 is a reasonable excuse to leave isolation early, then if the quickest way to do that and reduce the restrictions on people's lives, which is something I think was something parliamentarians would clearly understand why you'd want to reduce restrictions if things are getting better. That if that's the quickest way to do it, I think it's the right way to do it, as long as the government is very clear and transparent about that.
You're bypassing all parliamentary scrutiny in doing that. You think it's the quickest way. You think it's the right thing to do, understandably, yeah. But you're bypassing all scrutiny from all other parties.
I think with all these decisions, you have to decide what is not just about speed, although speed is an important factor, but it's about being practical. About what's the most practical way to change, to help people understand what the rules, when they apply and when they don't apply, and if every time the government wants to clarify things or to make a what is a relatively small shift but with a big impact, it came back to Parliament. And I mean, obviously these are all announced in Parliament, they're all explained in Parliament, they're debated in Parliament in the kind of change you're talking about. A number of times I would have gone to Parliament, other ministers have gone to Parliament and explained those changes and why they're happening, given the opportunity for parliamentarians to ask questions about them.
Excuse me, that's after the fact. You're still bypassing all parliamentary scrutiny and making changes which fundamentally affects people's lives without the use of any parliamentary scrutiny. Is that the right thing to do?
I wouldn't.
Even if you think it's the right thing to do, within the way this place works, is it the right thing to do?
Yeah. I wouldn't actually go My own view would be I wouldn't. You said it bypasses all parliamentary scrutiny. I don't quite think that is the case. I think if the government is changing guidance and being open and transparent and coming to Parliament through a statement and explaining why that is happening and why that change is being
openly and
made.
transparently and explain it, but if unless you involve other people and other bodies in the conversation to come up with the decisions you're making, then you're bypassing parliamentary scrutiny. If I can't stand up with you in front of it in Parliament and argue my point of view, and I say, we shouldn't be going from 10 days, we should be staying at 10 days, if I can't say that before this guidance is changed, then you've bypassed that scrutiny. You've come to me as a fait accompli and said, we're going to 7 days, we're going to 5 days.
Well, I think sometimes just given the speed at which we need to move and the impact, like for example the self-isolation legislation that require the guidance, that if we don't move at speed and everything is slowed down, because we took a different approach. And the challenge is that it will inadvertently affect too many lives in a way as that we could have otherwise have helped. So I think the general approach of again, take your example, the self-isolation rules for close contacts. The government, when those rules were put in place, obviously they were put in place by Parliament under the Public Health Act as regulation. And at the time they were put in place, I think it would be made clear to Parliament that they will come with guidance.
I fully understand that you think what you did was the right action to take. I'm not questioning that. But do you honestly tell me that if you were in the opposition and a Labour-run government were making those decisions and coming to Parliament saying, this is what we have done, you would not be screaming, where's the scrutiny?
I would want to make sure there's enough scrutiny. But I think it would depend on the context of the situation at the time, and if I felt that the way the government has changed guidance and the reasons, whether it was in the public interest or not.
I think what Mr. Cowan is the nub of the issue is, as I've mentioned it before, is the apparent confrontation between the legislature and the executive, notwithstanding all the merits and demerits of different cases. But it's to put it as simple as possible, well, if the Prime Minister has said something and people should follow what the Prime Minister has said, or should it be that Parliament has made a law? And I think it's that balance. Now, this is the context of a pandemic, which is very difficult, all kinds of competing demands, but really I think what we're driving at is how compatible is guidance or nudge in different contexts as well with parliamentary democracy and lawmaking. And so it's almost a philosophical debate that we're having. But I think, David, you wanted to come in?
Well, I just want to add a little bit of context, because the arguments Mr. Cowan are making are exactly the arguments that opposition politicians were made in Scotland because of the First Minister of Scotland's predilection for making announcements in her then daily television broadcasts rather than actually making those statements to Parliament. And my experience was that this Parliament, there were actually a much greater accessibility.
And if I may, Mr. Mundell, maybe Mr. Cohen, you would know better, but it's my understanding that the self-isolation rules in Scotland were done by guidance and not legislation.
I'm not here to scrutinise. I'm not here today to scrutinise the Scottish government. I can disagree with what they've done on a number of things if that's what they want to do. Well, look at what happens here in that building over here in Westminster and how it's handled the Coronavirus Act.
Yeah.
And we're not going what about it? Pointing other squirrels running left, right, and centre and said other people made the same mistake, or how did that government handle the situation? Because we're very good at doing that here. We're not the worst because somebody else has made a bigger mess of this than we have. We've got
I think we hear that statement very regularly in the Scottish Parliament.
170,000 people died in the UK because of the coronavirus, and we're looking to see how did we handle that and could we have handled it better. So simply pointing at other people and saying, well, they made the same mistakes as us, doesn't cut it as far as I'm concerned.
And I think we've made a marvellous attempt, as ever with this committee, to keep the party politics out of it and really just maybe it's something that that executives, regardless of their colour, are attracted to. John.
I don't want to tread on this private grief with regard to Scotland, but at times when it's come to announcements in Parliament, there is a view among some parliamentarians that actually it has almost been like peeping through the keyhole or shouting through the letterbox of number 10 rather than participating in a decision-making process over such fundamental issues. And I think that needs to be addressed at times. And the argument that's been put by my colleague that at times it's been like a fait accompli on issues that might have seemed relatively minor to government in terms of the change, but as you said yourself, could have a major impact on our constituents' lives. And I think that's a matter that needs to be considered about the judgment that is exercised in government, about the way in which Parliament can participate in a decision-making process around those issues. And I think at times it hasn't felt right that the level of scrutiny leading to decision-making has been fully engaging.
Yeah, look, I think, Mr. MacDonald, you made a similar point earlier, and I respect that about amendable motions, and you raised rightly the same issue around scrutiny. And I think we can, as I've said, and I absolutely believe that there will be a lot of lessons to learn from this process. And during the last couple of years, the government has tried very hard to try and strike the right balance between acting quickly and responsibly in an emergent situation, but making sure that parliamentarians are very involved in that process as they should be. But again, as I said to you earlier, I think there will be lessons to learn from this.
I think Ronnie to continue.
Yep. Sure. There have been over 550 statutory instruments laid that in some way relate to the management of the pandemic, some of which were superseded before they were debated in Parliament, and one was never debated or approved by the House. What would you do in future to reduce the amount of SIs in a similar situation and to ensure that the House has timely opportunities to debate for approval?
I think that always the government should strive to do what you say, which is to minimise the number of SIs relating to a certain policy initiative, but also to make sure there's enough time for debate. With reflecting on the pandemic, I think that it just depends on which SI it is and what is it you're trying to achieve and how urgent it is. And if I can just give an example about the so-called sort of red listing of countries, when if I think back to the start of the Omicron wave, when we identified that Omicron was of particular concern from certain countries, South Africa, Zimbabwe and others, we needed to move fast and take really quick action. And I needed to be able to announce that before Parliament had a chance to consider the matter. Over the weekend, I think it was, but then the SI obviously came later when Parliament was back in session. But I needed to announce it first for the obvious reasons that we want to make it clear that we're worried about this new variant, that people coming from South Africa may be carrying it, and make sure that they were aware of it. But also, if there were British people in South Africa, they were able to take that into account over that important weekend. And time was of the essence, especially when you had a variant at that time, even with the data that we had at the time, that it was more transmissible than anything that we'd seen before. So I just use that by way of example. It does depend on the context and of that particular SI and what it's intending to achieve.
So were we trying to do too much? Was there simply too much legislation? Were we trying to be too particular? Were we trying to dot every I and cross every T? When New Zealand handled this with a lot less legislation than we did.
Well, that's because I think New Zealand took an entirely different approach at the start, which was to seal off their country from the rest of the world, in effect, and that was really their main piece of legislation.
Were they wrong to do that?
Look, that's a matter for them to determine. I think that that would not have been at all practical or feasible for the United Kingdom at many levels. So it's. I just don't think the New Zealand experience is comparable to the UK.
We are here to scrutinise the UK government, Mr. Cowan.
Hardly.
Okay. You okay?
No.
Thank you very much. John MacDonald, please.
I just want to move on to talk about data and thresholds.
Yep.
Which department owns all the data gathered due to the pandemic response?
Mr. McDonald, when you say all the data, that's a pretty broad thing, all data. So I would not think it's a single department that would own all the data. And if I can just expand on that. So if it's health-related data, then clearly my department would be the obvious home for that. So around vaccinations, for example, case numbers, infections, and that type of information. If it's data on how many appearances in court were held remotely, then clearly my department, that would be the MOJ. So I think, obviously, and the Home Office might have information on law enforcement issues. So I don't think it would be a single department.
Is there a mechanism for the coordination of the examination of that data? And then how is that fed into decision making relating to elements of this Act, whether they expire or whether they're extended? Try and explain that process of how there's coordination of data within government itself.
Yeah, I'm happy to. So first, I think, depending on the provision that the government might be looking at, that will be particular to a department, let's say, would sort of own that provision. So provisions around the registration of clinicians. Clearly, my department might own that. MOJ might own provisions around courts. And then the first, those departments would clearly have a view on whether they need to continue that provision or not. But the eventual decision will be a cross-government decision. And throughout the pandemic, certainly in the time that I've been involved for the last 8 months, that is coordinated through the Cabinet Office, through a committee chaired by the Cabinet Office called the COVID-O. So that would meet on a regular basis and with all the relevant ministers. My department would always be represented because it's all ultimately related to the pandemic. But other departments, most of the sort of larger departments, are certainly those that have an interest in the Coronavirus Act, which is almost every department. And that there will be a paper prepared by the Cabinet Office with input from the lead department and any other department and any other advice from, let's say, the UK Health Security Agency or any other relevant advice, all in a single paper. That will be presented as one sort of joint sort of, let's call it a single view of all the facts and data, and then the committee of ministers would make the decision.
That leads on then to the issue with regard to thresholds.
Yep.
This committee has previously pushed the government to set out the thresholds or triggers for certain policy decisions. Are there any thresholds being used in justifying the government's decision around whether to extend the Act itself? And if so, what are they?
There's no individuals like single threshold or trigger. I think we look at a number of sort of metrics in data, and even when we look at those metrics, I don't think there's any single sort of threshold, as it were, of that. And so let me explain that. So as was said earlier at the start, and the Prime Minister set out in his statement in Parliament earlier this week, that in setting out our Living with COVID plan, clearly many of the legal restrictions are moving, and we're in that process of living with COVID. In making those decisions, clearly a lot of the data is absolutely considered, but it's a combination of data. So it will be around infection numbers from primarily from the ONS weekly survey, but other surveys like what's called Vivaldi, Siren, and other surveys. It would be case data, so the number of positive registered cases that will come from UXA. It will be data from the NHS in terms of hospitalisations, the trends in hospitalisations, the regional differences in hospitalisations, also data from the NHS on staff absences, on use of antivirals and other treatments, as in how many people were kept out of hospital, ill but kept out of hospital. So a number of sources of data taken into account collectively. With all those data that I've just referred to, they have all now, thankfully, for a number of weeks been heading in what you might broadly say the right direction. And so that is crucial. And all that data is not just then considered directly by government ministers, but is very importantly considered by the government's advisors, our scientists, the medical officer, chief medical officer, and others, and they will give their advice based on that data. The other thing I would just, I think, directly relate to your question as to why there's no particular threshold and a number, was because, again, it's about the context. So, for example, Omicron, we know on the one hand is much more infectious. So compared to, say, Delta, you might expect to see clearly a much higher level of infections, as the ONS data is showing. But we also know that intrinsically it's less severe, but especially if someone has been boosted. So we would look at the realised severity in the population based on the number of people that have been boosted, especially the more vulnerable groups. So over 50s, 93% have been boosted, so we take that into account. And then have more tolerance for infections given the knowledge that more people are boosted. And I only highlight that because when I first came into this job, obviously there was no Omicron, there was Delta. It was considered more severe, it was less infectious, but we didn't, obviously our campaign for vaccinations was still going. A lot of people hadn't even had their second vaccination. So you would have had a lower tolerance level. So I think for the government have to set a number and said, I'm not necessarily saying this is what you were suggesting, but if a threshold meant that, if infections go to this level or that level, then the government must do X or Y. I think you have to keep that under constant review.
Completely agree, and I think and completely rational. But the point that the committee has made in the past is about openness and transparency around decision making.
Yeah.
And that's why the committee has pressed in the past for the fullest publication of the data.
Yeah.
But also the fullest public display of the government thinking around the decisions that will be taken. And some of that will be around thresholds at certain levels, infection rates, etc., and length of stay, severity within ICTs, etc. And although we accept that will be a changing feast, obviously it will be, nevertheless it must come into government thinking. When you sit around that subcommittee and the data is being fed in, there must be some element of threshold decision making, admittedly changing over time because of the different variants.
Yeah.
There must be some level of decision making based upon thresholds, no matter how changeable. That it would be better, wouldn't it, to be completely, fully open and transparent about those thresholds that will determine decision making.
There will, as you say, it's not fixed, that threshold in any point in time, and it has to be under review given the context at that time. But in government's thinking, there will be I guess you'd call it thresholds that you'd want to try and either target and reach. And so if I give you an example, I referred earlier to boosters. And for all the reasons that I think now everyone understands, it became a huge focus in certainly over December, early January. And internally we had sort of set targets for the NHS vaccination program and others about how quickly we wanted to get more people boosted in the ways we wanted to do that. And I think a lot of that was rightly, I think, set out publicly and things because it was right, to be transparent, but also for the public, to explain to the public how it might impact them. So, for example, when I came to Parliament, a number of times talked about the vaccination programme, but when we accelerated the booster programme, I talked about why we had temporarily asked GPs to focus less on non-urgent work so they could spend more time boosting elderly people in care homes or people who are housebound. And it's important, I think everyone can understand why, but it's important we were upfront and clear with parliamentarians that this would have an impact on some of their constituents in a way that we would have liked to avoid, but it was unavoidable. So there would have been sort of targets and thresholds we would have had in mind. Also, I can give you an example of the NHS. The NHS prior to Omicron had gone through the Alpha wave and the Delta wave and dealt brilliantly with the challenges that it had faced. And it would have, through that experience, have each individual trust would have seen what the peak was of COVID hospitalizations in the past, and it would have not been unreasonable for a hospital trust to sort of it was a peak that they to learn from that experience and to look at Omicron hospital admissions in relation to that peak and where they were, and to try and judge what they might be able to cope with on that basis. So we've been learning all the time through the pandemic, and we continue to do so. But it's important that when we look at data, that it's always in the context and it's kept under review.
I think the plea from the committee is the openness and transparency around the decision-making process, so that when different elements of the Act are judged to be no longer relevant, that actually that's based upon a determination of the data that is available, and also, in some instances, where there's an ambition to stand down part of the Act, that there's clarity about the thresholds, the factors, thresholds that need to be taken into account and they've got to happen. Otherwise, at times, there can be suspicion that other matters, political issues confronting the Prime Minister or whoever are more important than actually the objective reality of what is happening on the ground.
Yeah, we must be as transparent as possible at all times. We're transparent, but as much data as can be published. And I think that whilst there was a lot of data shared and it increased over time with the dashboard data, the SAGE information, the minutes, the vaccination evaluations that we did, and we were very quick to publish all that data, and indeed partly because we obviously wanted to share with parliamentarians, we want to share it with the world as well, because it can help many other countries. NHS data, I think one of the points you make, and I respect this, I think it's a very fair point, is that as we learn lessons from this, we've got to think: was there more data? Could more data have been released in a more structured and more regular way for the reasons that you said? And I think that's a very fair point.
The final tranche of questions from me in conclusion for the committee. There may be supplementaries from colleagues as well. And really to try to draw together some of the strands of what we've been discussing this morning. And I just wondered if you could envisage circumstances where the Civil Contingencies Act would be used during a pandemic.
The Civil Contingencies Act is there for a purpose. I think it's right that we have, broadly speaking, such an act. I think that it should only ever, as I believe when the Act was passed by Parliament, this was the logic given, that it should only ever be used if there are really no other legislative alternatives. As I explained earlier, in this case, I don't think it would have been indeed necessary or appropriate to use it. Your question was, for future public health risks, serious public health risks, are there any circumstances? I wouldn't rule it out. I don't think it would be sensible to rule it out.
So that theme then, really, are there plans to revise emergency provisions in relevant legislation, regardless of what piece, to create a more standard set of scrutiny and accountability measures if we now have not quite the leisure, but at least a period of time for reflection and learning? Are there such plans?
There are. There's definitely a desire and a plan, I guess you could call it, to properly learn the lessons of this period of the last couple of years. It's not over yet, as we know, but to make sure we learn the lessons. And in doing so, the exactly what we're discussing today, for the reasons and the scrutiny provided by this committee, other committees, the public inquiry, there's no doubt in my mind that will lead to changes that I think that will better prepare us for the future.
I don't want to play devil's advocate slightly with this next question, but what analysis has been done on whether any provisions due to expire at midnight on 24th of March would be needed to respond to, say, a new variant, and how would the government plan to deal with them given that this legislation would expire? Would we be back to the same point we were 2 years ago in bringing something forward with minimum?
No, I think thankfully we've built huge and very significant defences over the last 2 years. The vaccinations, continued vaccinations, of course, with a recent announcement just this week of a second booster for a certain cohort of people, the treatments that we have today, the testing capabilities we have today, including the ability to genomic sequence and understand future variants of concern, the surveillance programs we have today, the ability to detect and rapidly respond. So I think it's a completely different picture today than what we had before.
In terms of maybe a much more less dramatic sense, the role of Parliament and the nature of the legislation underpinning it, you don't envisage having to you simply say you would react to the events as you found them?
I would. If your question is, do I envisage having to? I think that was your question.
Yes.
Some of these retiring provisions to have to try and bring them back. No, I don't envisage that for the reasons I said.
Okay, and just it's our understanding, as has been touched on earlier, that the draft pandemic flu bill existed, and some measures formed the core of the Coronavirus Act. Hindsight's a wonderful thing in all of this. But I just wondered how much stock emergency legislation is there sitting on that metaphorical shelf?
Well, they're clearly before this pandemic, there was the draft flu bill. Now, alongside that, we have this particular bill and the lessons from this bill. And as we, through this debate and others, as we learn more, I think that and we haven't learned clearly all the lessons yet, but as we do, I think it would make sense for the government to try and then consolidate all those lessons and maybe come with another sort of draft bill to have in reserve for future pandemic response. You take into account all these lessons.
In terms of concrete proposals, as it were, are there any such things? Is there, others outside of this committee, members of this committee have called for a new Public Health Act, for example? Is that something that
there are no current proposals for a new Public Health Act? It's worth just pointing out, as I understand it, the 1984 Public Health Act was a sort of larger consolidation act of many previous measures. So I only point that out just for the knowledge that it wasn't sort of Parliament at that time woke up and thought we need to have these measures. The kind of ideas and measures on statute books have been around for decades. And I also believe in 2008 there was a substantive revision of the Act. If your question is that really is there a need for another substantive revision of the Act, that is not something the government is currently working on. But I think it is a perfectly reasonable question to ask, given what the country has just been through.
Okay, my colleague John McDonnell has a question.
Just to follow up the point that you made, that you made, Chair, the key thing, and I'm not accusing you of this, the key thing is not to be complacent at the moment because of the potential of new variant or whatever. But the point the Chair was raising with regard to, wouldn't it be better for us now to be in a situation, having learnt the lessons of the implementation of the Coronavirus Act itself, to have at least now a discussion about the potential of a draft legislation to be on the shelf in case of elements of a new variant or whatever happening in the future. So the lessons that you were hopefully learning from your own internal review, displayed them and shared with Parliament, would enable us and this committee in particular to be engaged in the discussion about a draft bill that can then rest on the shelf, which could have an element of core features that can then be flexibly adapted to whatever then element of a new variant or whatever crisis then hits us at that stage, rather than to have to simply re-engage or even bring down the old legislation without having it even amended in draft.
Look, I understand that, and the government isn't working on such a draft bill at this point for the reasons I've shared. And your question about should that work sort of happen sometime sort of soon, and so there's a draft bill Parliament's already considered. I understand that. I guess the challenge back would be that we just don't know what the next pandemic is going to look like, and I already talked about how clearly the government had planned for lots of sensible reasons, like most of the world, for influenza-based pandemic, and this was very different, and we know how it's transmitted, the fact that it can be asymptomatically transmitted, it made a huge difference. But what if the next one's a fungal infection and things that we've planned for, like a COVID-19 type infection, or what if it's an influenza type of plan? So I think you might just then run the risk, it's so draft, it's so sort of uncertain that what's being presented to Parliament that it actually doesn't serve much purpose. But that said, I'm not ruling that out. But I just wanted to sort of set out it's not that straightforward.
Well, thank you very much indeed for your time this morning, Secretary of State. We're very pleased to have been able to welcome you to our committee, away from the Health and Social Care Committee. If there's anything else you wish to furnish us with, please do write. But for the time being, thank you very much.
Well, thank you very much to you all, and I look forward to next time.
Thank you very much.
Thank you.
Order.
The proceeding has ended.